Now, over the past 2 months, we have been discussing the challenges in the land sector and the causes of those challenges. We've also been explaining the due diligence role that individual landowners have to play to improve chances of securing their land rights in spite of the challenges in the sector. Our final discussion before the Christmas festivities, we focus on documentation of land rights. All over the world, there's evidence that documentation of land right is an important step towards securing your land rights. And so we have been encouraging you, our viewers, to ensure that we have that documentation, that your documentations are done right. But what kind of documentation is required, and what should one expect to see in a land document to be certain that that document will be protecting his interests? In the studio with me, his or her interest. Studio with me is Nana Ama Yirrah, Executive Director of COLANDEF, and George Kwesi Esau, Land Administrator at the Land Commission. Lady and gentlemen, once again, you're welcome.
Thank you.
So I don't know which of you want to start, but let's talk about, when we talk about land documentation for land rights, what really do we mean?
Okay. Thank you very much. And I would like to say good afternoon to our viewers. I just want to make a small point to establish why we are saying documentation is critical for securing land rights. I think over the past few months, we've been talking about the fact that in Ghana, the laws allow different types of interest in land to exist on the same parcel of land at the same time. So as the allodial interest is there, which is held by the custodian, be the chief or family head or whatever, you could also have other interests all existing on the same parcel of land. So what that means is that while the land is there, there are different owners of that same parcel having different types of ownership. Wow. So you realize that if you do not document the type of ownership that you have, over time, it becomes very confusing. Okay. Because then between you and the other owners, what are the differences? So let me just try to break it down. So a chief who is holding a land in trust for the land owning group holds the allodial interest. That allodial interest is held forever and ever. That interest can, out of it, a chief can grant a leasehold to an individual. For a period, say 99 years. So while that 99 years is running, the allodial interest is still there.
Okay, the chief so
exactly. As it hasn't been extinguished. It's still there, except that out of that allodial interest, they have granted you a leasehold interest. There are, in some cases, in some of the farming areas, some people have acquired a leasehold waiting to mobilize some money to undertake some investments. So while they are waiting, they have also granted permission to some farmers to undertake some farming activities. And there are some terms under which they allow them to occupy. So while the allodial interest is there and has out of that been granted a leasehold to another person, and the leasehold person has also granted some form of permission.
Is that legal?
It is.
Okay.
It is. So the farmer may have a bunu or a busa or any type of arrangement between him or herself and the person who acquired the leasehold. That is legal. Okay. But that is what we mean when we say that different types of interest in land can exist on the same parcel of land at the same time. Okay. Because of this, it's important to document what kind of interest each of the people have. Okay. So, for example, in the case of the leaseholder and the farmer, it's important for the leasehold interest holder to have some documentation to clarify what type of permission he has given to, so that it becomes easier to distinguish between the different types of interest.
Let me come to Mr. Esau and bring you into this conversation. I don't know if you had anything to add to what Nana Ama has already said, but I also wanted to find out from you, what are the sort of arrangements at the Lands Commission when it comes to the things that she has just said?
Yeah, basically it happens outside Accra. Mostly Accra lands are for residential, commercial, industrial, but when you go to the outskirts, as said by her, allodial interest is the most supreme form of interest in land. So you may have the allodial interest that you can grant the leasehold interest. Then leasehold will be for 50 or 99 years. Others may have use rights. Basically, that's the usufruct right. That is the right to use the land. The right to use the land. Some people will have another right called easement. Somebody may have license over the land.
So explain to us when you mention the technical words, because we don't understand. What's easement?
Yeah, easement is where you would be given a use right for the land for a particular period of time, while the leasehold interest is still subsisting in the property.
Okay.
So as I said, the allodial owner is always having the supreme interest over the land. Then out of the allodial interest, a leasehold interest will be granted. Another person may have license to use the land. Another person may have an easement, also a right, or another word say profit apparent. Somebody may have the right to go onto the land to take certain things from the land. Yeah, so these are all form of uses that exist at the same time, but then the leasehold interest become the most substantial interest in the property, which is usually registered at the Lands Commission.
Okay, Nana Ama, you are into looking, you get into, you know, these arrangements, and then you are able to point us to some of the gaps, if there are. Are there any gaps here that we need to address so that perhaps we can take them?
Yeah, so I think one of the biggest issues is exactly what he mentioned, that the Lands Commission focuses on leaseholds and they register leaseholds. And that is the biggest challenge we have in the land sector in Ghana. And that is why a lot of the times we have challenges with the other interests. Because he clearly mentioned that apart from the leasehold, there are many other interests that can subsist at the same time. All of these are quantifiable interests in land. They are significant because whichever way you look at it, it is an interest in land which is given permission to another person to conduct any activity on the land. So for whatever reason, for whatever arrangement under which this is made, it's important that within our framework for land governance, we consider these other types of interest, because it is that which will help us to give it attention and have a policy direction on how to organize these other interests, both in terms of documentation and in terms of registration. But to come back to our conversation today, talking about the documentation, whichever type of interest, whether it is a leasehold, whether it is a customary freehold, whether it is a usufruct, whether it is whatever, there are different terms. Whatever type of right or interest in land that has been acquired, documentation is important because it gives you clarity on what has been granted and the terms under which it can be used. Okay. So to help our audience, our viewers, we just want to say that every kind of land documentation you have should contain certain features which will help you to know that this agreement is good, or this is lacking something. Okay. I always use very simple, expressions to help, because many people have the lease document, the indenture. Many of them have not even read it before to know what it contains, or may not understand exactly what it contains and what it means for them.
So you have a simple way of helping people understand that. Okay, let's go through that, then we'll come to Mr. Esau again.
So it's 4 P's and S.
Okay.
The first P stands for the parties. That every land agreement that you hold, it should specifically and without any ambiguity identify who the parties are. Okay. And the parties should be one party is the one who is granting the land, and the second is the one or ones who are receiving the grant. So the parties need to be defined and clearly identified.
That's 1 P.
Then the second P is the price. That is how much is given for this land. It could be in terms of cash, it could be in terms of other arrangements, but it all constitutes the price or the consideration for the land. The other P is a period, the term. So every land agreement should contain expression on the term. How long is this being given? Is it 50 years? Is it perpetual? Is it for a period? What is it? It is important to have it. Lack of it creates confusion. And then the fourth P is a parcel. What land parcel is this agreement referring to? So in many of the land agreements, you see that there's a schedule where they describe the parcel in very technical terms. But whatever it is, we want our listeners to know that it's important to have a description of the parcel. Because if you have the land agreement and the parcel description is not in, it's difficult to relate that agreement to a particular land parcel. So those are the 4 Ps. The parties, the price, the period, and the parcel. And then the signatures.
The S is a signature.
We have encountered many people who have land agreements and they themselves, their signature is not on.
Why is that a problem? You can always sign anytime.
It's a contract. It's a contract. So the contract should be prepared within a certain framework to make it legally binding. So the person who gives the land has signed with his witnesses. You who is receiving and who is committing to obligations in that contract should also sign. And that is what makes it fully.
So if I don't sign, and I mean, I have the document, it's mine, but I have it, but I have not signed. But then the person who is leasing the land to me has signed.
No, it's important to sign. It's a contract that is establishing a certain obligation and benefits between 2 parties. One party is the one granting, the other party is the one receiving. So the 2 sign and have their witnesses also sign. And that gives you a good land agreement. And I just want to add
let me just quickly, if you just hold on for me, because I want Mr. Esau to talk us through the 4 Ps and S, and then how the Lands Commission come in this kind of arrangements, if you will. Otherwise, whatever it is that you want to add on that before Nana Ama comes in with her final comments on that one.
No, as she said, without these elements.
So the 4 Ps,
without these 4 elements.
Do you want me to go through them?
I'm okay.
Good.
Without these 4 elements, you cannot come to Lands Commission to perfect your title. Because you cannot come to Lands Commission with a leasehold document without a party signing the document, or you not having a party to the agreement. There should be the grantor and then the grantee, which are the contracting parties. If they are not clearly stated in the leasehold or assignment documents, then Lands Commission would return your document back to you to do the needful before you can bring it back for registration. I'm much concerned about the parcel, which is the land itself. Normally people say, I have a document. They will come to Lands Commission without a site plan in the document. And the parcel itself is a site plan depicting the land.
Go through that again, Phil, please.
Yeah, as I'm saying, the parcel, as one of the P, she said, is the land per se. Yeah, without the site plan describing the parcel.
We don't know
what you're talking about.
We don't know.
As we sit here, anybody at all can print a leasehold agreement from a PC. But we are looking at the parcel we are talking about. So the schedule, to me, the schedule is very necessary. Without a schedule in a leasehold document, then there's nothing we are talking about. So the parcel is very necessary.
Is very important.
And then another part I want to emphasize is that many times people come to Lands Commission with a leasehold document without, we have a component called deponent where someone is supposed to sign. And people don't know who is supposed to sign as a deponent. Deponent is the witness to the grantor. No one else can sign at the deponent section except the one who witnessed the document to the grantor and not to the grantee. Which is very critical. Many times people bring the document.
That's interesting. Say that again. So no one can sign the section, the witness. The section for the witness.
Any leasehold agreement where we have the oath of proof and a solicitor, we have a section there called deponent. Nobody can sign that section except the first witness to the grantor.
So if you do not see the transaction take place, you cannot sign the document. Is that it?
Yes, because you see, the witness to the grantor is the one indicating to the contracting party that at the time of the contract he was present. for which he signed, he attests to the document.
Okay, and if you don't have that signed, or
if you don't have that signed, we cannot continue. We cannot start the registration and finish the registration.
Interesting. Is there anything else you want to add before I bring Nana Ama in? No, Nana Ama has a lot of information, and she can go on and on and on. Yeah. So if there's anything you want to add, do let me know.
Also, the date of the document is very critical. Because before the agreement will take place, then we know the parcel. The parcel should be described before we can sign to the document. Many times you notice that the date on the site plan is before the date on the date on the site plan should be more. It shouldn't be current than the date on the document itself.
Okay,
you understand? Because the surveyor has to go to the site, pick the points, and get the parcel prepared before they can agree to the agreement.
Okay.
Yes.
Nana Ama, you wanted to add something before we went to Lands Commission for the comment on the 4Ps and the S.
Yes.
Do that, and then the response you had for this one as well.
Yes. So I just wanted to emphasize, and I think he mentioned it, that so having the agreement, the land agreement properly executed is one, but also having the site plan is critical. So it is the two together that makes one have a complete land documentation.
Okay.
If you have the land agreement which is duly executed but without a site plan, it's incomplete. And at the same time, if you have the site plan without a land agreement, it's also incomplete. So you need both of them to help you to, be able to defend your rights over that land. But I also want to say that personally, I think we need to do another session on this, because it's
on the land
documentation, Gifty.
I kind of feel like these are things. So once you are able to clear the hurdle of making that transaction, when it comes to document, I get the feeling that people are conscious of the need to get the document right. Is that not what you see in your dealing with?
No, people don't know.
People don't know.
Many people, in fact, I've had situations where people did not even know that the lease has an expiration period.
I mean, that's because perhaps 99 years, that's like...
No, it's not that. They simply, and these days, people assume 99 years, but these days...
They're cutting it down.
Exactly. And people haven't taken note of it. I've also told you...
Is that legal? Is it allowed?
No,
as in cutting it down?
No, you have to. It's negotiation.
Okay.
So if you want to give me a 99-year lease, we should agree. If in my mind, I'm negotiating for 99 years, but in your mind, you are giving me 50 years. It's not...
It doesn't work that way. I'll come again, Nana Ama, because I want to find out what the perspective of the
I said by Nana. No. I said by Nana Ama.
Yeah.
The duration depends on the contracting parties.
Yeah. Okay, so there is no
there are instances. Okay, if you're a foreigner, you cannot do more than 50 years per the 1990 Constitution.
Okay.
But then, if we are all Ghanaians, I can decide to give you 70 years, 90 years, 150 years.
So if you're a foreigner, it should not be beyond 50 years.
No, you cannot.
I've heard of stories where people are given 50 years in an area, and I don't want to mention the area, in an area where supposedly a lot of expatriates live. They did not look at the documents and realized later that it was 50 years. But these are Ghanaians. I mean, in situations like that, what do you do? They are Ghanaians, but they went to a place where presumably the residents there are expatriates. And so they were given 50 years, but they did not even look at it. It was later that they took a look at it. So in that case, Mr. So what do they do? Nana, I'll come to you after this one.
Before I even answer your answer, currently, Lands Commission, we grant 50 years lease. We don't do more than 50 years.
For Ghanaians?
For Ghanaians, yeah. You see, if you're a foreigner, you cannot do more than 50 years.
No. For Ghanaians, you said you're doing 50 years.
For estate management purposes. We've decided to give 50 years. Many a times we grant 99 years. They are supposed to pay ground rent every year. They will never pay the ground rent until they want to assign their interest. So the idea is that if we cut it down to 50 years, then there's a possibility of me meeting such people before I even retire from the public service. But if you give them 99 years and they are not assigning the property, they will never come to Lands Commission to pay ground rent.
That's the reason why Land Commission has changed the
Not entirely, but then we are looking at land, scarcity of land. We cannot increase the land we have. So if you do 50 years, we would have the opportunity to...
I mean, that's an interesting revelation there. Nana Ama, you don't agree?
So the point is, the number of years that is given for any lease period is determined by the one granting.
The people involved in the transaction.
The people involved. So there is no such thing as it is definitely supposed to be 99 years or definitely supposed to be this or that. No, it's based on what you negotiate for. But what I am saying is that previously we have known that for residential purposes, the law allows that you give up to a maximum of up to 99 years. For agricultural purposes, up to 50 years. And for foreigners, 50 years, and so on. So there are laws that regulate the number of years for leases for different purposes. Maximum number of years. So if it says maximum number of years for residential purpose is 99 years, it means you cannot go beyond 99 years. But of course, you can go below 99 years. And it is all based on negotiation. It is purely contractual. But what is important is that if I am not getting 99 years and I am being granted 50 years, it informs the transaction. So if I am supposed to pay for an X amount of money, and in my mind I'm paying that because it's a 99-year lease, but I'm not giving that, but I get 50 years. It means it's not really a fair deal. And many people don't know this. And so when they are transacting the land, they only consider the size. That, oh, it's a 1 acre, oh, it's one plot, and therefore they say it's this much, and so it's good. But do not just look at the size, look at what is being given. That is the number of years in terms of the interest.
Okay, I'll take your final words, Mrs. So. Final words.
Well, the interest, as in the duration we are looking at, we can even decide to give 20 years. It's just a policy. It depends on the contracting party. For instance, when we are talking about state land grants, Lands Commission can decide to give 30 years term. Even for industrial, we cannot go beyond 50 years because you are operating an industrial activity on the property. You are making profit day in and out. If we give to you for, say, 99 years, when would you come back to Lands Commission again? When you give you a period of 50 years, we always have the right to retain the reversionary interest. When you are running an industry and you have 5 years unexpired term, nobody will ask you to come to Lands Commission for surrender renewal of the property to have a longer term, especially where you are expecting investors to come in to operate in your industry and have lesser term in the land that you are operating on. Then you will be compelled to come to Lands Commission to surrender your interest and renew for a longer term. So with the duration, it's up to the contracting parties to agree on the term.
Okay, we've run out of time for today, but certainly we'll have a lot more time as the weeks and the months progress. We're going into a new year. We'll certainly keep this story in the news and we'll keep talking about it. Thank you so much for coming. Nana Ama Yirrah is with COLANDEF. Like I said, if you give her a whole hour, she can go on and on about land. George Sell, thank you very much for coming. He's also with the Lands Commission. I just keep, anytime I mention his name, Road Safety keeps coming. Road Safety Commission keeps coming up. I don't know why. But yeah, hopefully this has given you some enlightenment about land.